Well, good morning, everyone. I can see that I think most attendees have joined us now, so I'm going to open this morning's event. Can I welcome you to the second of this year's 4 New G lectures, which considers rectification in light of the Four Seasons case. And I'm delighted that we've got James McCreath and Jonathan Chu as our speakers today. Both will be well known to you. Both have stellar recommendations in the legal directories. They are true experts in pensions matters, and I have some personal experience of this, having been against James and had Jonathan as counsel to the determinations panel in a case I was involved in. I'm delighted and relieved today that they're not opponents, and I get to ask them the questions. Thank you both in advance for your talks today. Speaking of questions, please do ask them. You'll see at the bottom of the screen a Q&A function. If you click on that box, a typing box appears. You can put in your question anonymously, but one advantage to putting your name there is if we don't have time to deal with the questions this morning, we'll drop you an email in the next couple of days or so and hopefully answer them that way. And I think James and Jonathan's plan is that we look at legal principles first and then evidential issues. We'll try to have a break in between those and have some questions in the middle and then again at the end. So without any more ado, can I hand over to James to start us off? Thank you.
Thanks very much, Tom. As Tom says, we're going to start with legal principles and then move on to evidential issues. And I'm going to start the legal principles section by introducing Four Seasons and how we've got here. Now, in 2012, no less an authority than Christopher Nugee QC remarked in an article that he used to think he understood rectification reasonably well. Ours is a legal system which prides itself on the certainty of the principles it applies in a commercial context. It's a bit surprising, therefore, that some of the most basic principles governing written instruments have proved so controversial in the last decade or so. Questions of implication, the question whether construct and implication are the same thing, and of course questions of rectification. But the fate of the principles governing rectification is perhaps the most extraordinary. Whereas the revolutions which Lord Hoffman sought to inspire in construction and implication had to be undone by the Supreme Court, in rectification it's the Court of Appeal that stepped in. So, how have we got here? Well, the story begins with the findings of fact of Mr. Justice Briggs, as he then was, in Chartbrook and Persimmon. As is well known, that case concerned the formula for the calculation of the purchase price of certain development land. And there was an exchange of correspondence prior to the contract, which indicated that the landowner accepted that the formula would work in a way that the developer subsequently argued for, the way that the developer. Notwithstanding that, Mr. Justice Briggs accepted the evidence of the landowner's directors that they subjectively thought the formula worked in the way that they contended, and for that reason he refused rectification. When the case reached the House of Lords, the developer's contention was accepted as the proper construction of the contract. But the House of Lords went on to consider, obiter, what the requirements for rectification actually were, and in doing that introduced revolutionary change. Rather than seek out the parties' subjective intentions, at least in the case of contracts, the hunt, the House of Lords told us, was for a prior consensus, the content of which was to be objectively construed. Now, that of course was in the contractual context, as was the subsequent Court of Appeal case applying it, the case of Daventry. So too was the Four Seasons case. That was a case concerning security documentation. Security documentation was meant to be put in place over a shareholder's loan, but it did more than just create security. It created a primary obligation on the claimant to pay indebtedness. And the judge at first instance held that objectively and subjectively, that was not what the parties had intended. And on that basis, he granted rectification. The appeal to the Court of Appeal did not seek to challenge the judge's findings about subjective intentions, but it did challenge his findings about objective intentions. it happens, the Court of Appeal, at the end of their long judgment, held that the judge had correctly construed the parties' objective intentions. And that would have been sufficient on any basis to dispose of the appeal. But the court didn't stop there. They went further than they had to, and they grasped the nettle and asked whether the objective test was the correct one. And their answer was that it was not. What matters was the subjective intention of the parties. That conclusion is the result of an exhaustive analysis of the authorities and consideration of the competing precedental status of contradictory decisions. To even try to summarise it now would take much, much longer than we have time for today. So rather than do that, I want instead just to mention briefly 3 features of the case because of the impact that they may have in the pension sphere. The first is that the Court of Appeal held that in the case of a written contract, whether the parties had a common intention in respect of a particular matter is to be judged subjectively. It's a matter of psychological fact of what was going through the parties' minds. Second, the Court of Appeal held that there had to be an outward expression of accord such that the parties understood that each other intended the same thing. And that's a significant finding, as there was Court of Appeal authority saying that an outward expression of accord was nothing more than an evidential factor in judging whether or not the underlying intention existed. And that's also the basis on which pension cases have proceeded to date. And third, the Court of Appeal expressly confronted that issue in the pensions cases. It referred to those cases with apparent endorsement and held that while contractual cases require an outward expression of accord, it is sufficient in cases where consent is necessary that the intentions of the trustee and the employer happen to coincide, even if they never actually discuss that. And I'm now going to pass on to Jonathan to discuss how safe that distinction actually is.
Thank you, James. What I want to do with you is look first at the reasons why Lord Justice Leggett said that this was a requirement in a contractual case, and then go on to see what he said in respect of pensions cases and whether or not that distinction stands up. So in his summary of the requirements for rectification at 176, just so we all know what we're talking about, Lord Justice Leggett held that in respect of a written contract and the document that records it, it is necessary to show an outward expression of accord, meaning that as a result of communication between them, the parties understood each other to share that intention. Now, as James has foreshadowed, in doing that, Lord Justice Leggett went against the flow of existing authority. There was extant Court of Appeal authority in Munton Beasley, that it was a purely evidential factor. And in the pensions case of Gallagher, which I'm sure we'll all be familiar with, it was specifically argued and decided that it was merely an evidential factor. Chitty treated it as an evidential requirement. Hodge on rectification more or less did as well. It's interesting and telling of the weight of the Four Seasons decision that there's been relatively casual disregard of an existing Court of Appeal authority on the point. But given the wider attack on Lord Hoffman, it may not be that unexpected. So what happened here was a narrow distinction on the grounds of contractual analysis. Again, it's James's point about the delicate trail through the authorities exhaustively, that none of the other cases apart from Gallagher were in fact authority for the proposition that outward expression of accord was merely evidential, and Gallagher was different because it was a pensions case. So why then do you need, as a matter of law, an outward expression of accord for contracts? Leggett LJ gave 3 reasons at 77 why it was sound in principle, and I've summarised those on the slide. The first reason was that the power to rectify is a power to correct mistakes in recording what had been actually agreed, not to make an agreement for the parties. The second reason was that rectification is something that rewrites, to make it accurate, the written terms of a contract. Therefore, this could only be justified on the parties' mutual agreement, and contractual agreement is based on an objective intention, so you need an outward expression of accord. And the third reason, which is sort of the negative reason, is that it would be capricious for a document to be rectified to make it comply with one party's private intention, just because, unknown to that party, the other party shared the private intention. If a private intention wasn't disclosed, where is the injustice, or where is the unconscionability in holding the parties to those terms? And so why do you need to step in to rectify at all? There may be an unspoken reason for the elevation of outward expression of accord to a requirement of principle, which is to mitigate against the risk of rectification based purely on subjective intention upsetting bargains. So maybe that was why. Going on to why pension schemes were said to be different. Having been driven to accept that there was authority for the proposition that there was an evidential requirement because it had been argued, Lord Justice Leggett then went on to agree with it. And we'll all be familiar with the cases from AMP and Barker through the first round of IBM where these issues were considered and decided. Two reasons really were given for why pensions cases were different. The first is that the power of the amendment power itself is drafted in such a way as to require the consent of the employer. Lord Justice Leggett went on to say, in this situation, no agreement between the trustees and employer is needed in order to effect a change in the rules. It's sufficient the employer gives consent to the proposed change. So I'm going to treat this reason 4 as consent as drafted, meaning something different to agreement. And then reason 5 was an analysis that the type of consensus required where an amendment power requires consent is a different animal from the agreement or consensus which is relevant in a contractual case. And that was taken from IBM but approved in 4 seasons. So reason 4 is the wording is different, drafting is different, consent not agreement. Reason 5, there's something qualitatively different about trust schemes. Now, Lord Justice Leggett is now Lord Leggett. This judgment has been near universally acclaimed from what I've seen. But I'm nevertheless going to have a go at suggesting today that this distinction between pensions cases and other cases may not be justifiable. And I say this because the first 3 reasons, the positive reasons for requiring outward expression of accord, are not contract specific, it seems to me. And the 2 negative reasons for distinguishing pensions cases at least arguably results from an overgeneralization of the proposition. So let's look at those reasons in a little more detail to see if they do in fact work. So reason 1, rectification doesn't make agreement but corrects errors in recording them. Well, that is as true of pensions cases or any other documentation as anything else. So I don't think this is really a standalone reason. Actually, what it is a logical precursor to reason 2. It's just identifying what rectification is doing. But if you rectify a pension scheme, you do so because there's been a mistake in recording it in exactly the same way as a contract. So what about reason 2? Contractual obligations and rights are based on objective intention and mutual assent. Well, my suggestion today is that these are both true for private law acts in general and the operation of pension schemes in particular. It's a broader truth about how we approach in law both intention and assent. Dealing with intention first, we will all be familiar with the number of cases at the highest level in recent years on how documents have been interpreted. You apply the same objective test to all of them, and you place the appropriate weight according to the legal and factual context. But that's not to say we have different rules for different things. I could list them all out, but I will just note 2 examples of that. The first is Marley and Rawlings, a wills case that specifically disavowed the idea of separate principles of interpretation in wills and settlements. And the other one, obviously, is Bernardo's, where again, the approach to interpretation of pension schemes was treated as being in the usual run. So if unilateral documents like wills and trust documents like pension schemes are to be interpreted in the same way, using the same objective principles as a contract, why should an application of an objective test elsewhere in the law be different? And it seems to me the notion of mutual assent has the same issues. Mutuality and the need for mutuality depends on the document being bilateral. There's no such thing as contractual assent necessarily, it's mutual assent. Take a cession to a pension deed, for instance. You've got a new member or a new participating employer. There would need to be the appropriate invitation under the rules, the relevant deed or document would need to be executed. So there's mutuality there, but not contractually so. And insofar as it relates purely to the need for assent, well, even in unilateral documents, you need assent in order for someone's rights to be affected. Freedom of contract, most obviously, but any beneficiary under a will or a trust has the right to disclaim a benefit that would otherwise be conferred by another's unilateral act. So those two limbs of reason two, it seems to me, don't necessarily require you to treat pension schemes differently. So what about caprice on the idea that you shouldn't let parties' private knowledge interfere? Well, again, pension schemes are commercial instruments, complex multi-party instruments in respects of funds to which both members and employers have commercially contributed. Why does this argument, if it applies to contract, not apply to pension schemes? So if they are general reasons, what about reasons 4 and 5 to carve out pension schemes? So let's have a look at reason 4, which is the word consent being used means it's different to some kind of contractual agreement. Now, as far as it goes, that's a legitimate reason for distinction. They are different words. But query, first, how much difference is there really between notions of consent of two parties and agreement? And secondly, how much was that difference appreciated and intended by the draftspeople? Now, the majority of the reported cases on amendment powers and their exercise use the word consent rather than agreement. But just to suggest that a distinction as a matter of words isn't the way forward here, I pray and aid 2 points. The first is Lord Briggs in Safeway and Newton in the Court of Appeal summarised the consent requirement as requiring, quote, the agreement of the scheme trustee. So it seems to me, at least in this context, another member of the Supreme Court is not necessarily saying there's a distinction between the two. And secondly, there may be other documents out there, scheme documents, that use agreement instead of consent. The PLC standard draft, for instance, at clause 6.1, refers to agreement, and we see elsewhere in other powers reference to agreement. So whilst it may be legitimate to treat consent as different to agreement, it then opens up the real prospect of the substantive test for rectification being different for different pension schemes depending on the wording of the power that's being adopted. And it seems to me that would be a far from satisfactory outcome to a rectification claim for the decision to depend on whether consent or agreement was required under the deed. The schemes aren't materially different, but the legal test would be. Essentially, you'd be running again all the problems around validity of amendments that we know from the formality cases from Best Trustees and Stewart through to Gleeds, which I mentioned hesitantly doing a talk with James. But it seems to me even pensions litigators would not want to go through that exercise again, depending on the difference between amendment and consent. So if that's not a wording distinction, if reason 4 is potentially unsatisfactory, what about reason 5, that there's something substantively different between agreement or consent in the pensions context versus the contractual context? Well, again, that may, it seems to me, be doubted. First, as a matter of principle, why should you treat the words differently? Literally, they mean the same thing. Substantively, they are intended to convey that of consensus with another person. Secondly, if the analysis of reason 2, that objective interpretation and the need for assent or mutuality applies to pension schemes. Why should that not apply here? Thirdly, there's nothing in the authorities that deal with the questions of agreement in the context of pension schemes that say a different type of agreement is needed. One example of this is IMG, where Mr. Justice Arnold considered an extrinsic contract. He held that there was no intention to create contractual legal relations because the parties were operating through the trust structure. But he didn't say the notion of agreement is itself different when you're dealing with a pension scheme context. So that core point, that there's no suggestion of a different approach to intention when considering pension scheme intention and agreement versus any other, stands. Similarly, there's nothing in any of the authorities on interpretation that suggests this should be different. I ought to just flag as well that prior to Four Seasons, there was authority that outward expression of intention was unnecessary in the cases of purely voluntary dispositions. But it seems to me a consent requirement makes it a bilateral, not a unilateral voluntary disposition. And there had been an Australian academic suggestion that you only need outward expression of accord where there's an actual negotiation or a bargain. And in pension scheme amendments, if there's not a negotiation or bargain, you don't need to look at it. That seems to me to be quite a difficult test to apply in practice and doubtful in principle. Finally, for this section, despite everything I've just said, it appears settled, at least at the Court of Appeal level, and deeds requiring consent in their wording, that no outward expression of accord is necessary as part of the test for rectification of the pension scheme. Certainly in 2 pensions rectification schemes before the Masters applying Four Seasons, it wasn't treated as a necessary requirement and not argued. That's the Blatchford and Colart cases from this year. It seems to me that the requirement of an outward expression of accord, whether evidential or substantial, significantly limits the importance of subjective intention. And in due course, I think we're going to talk a little bit more about that evidential context. Well, I'll just pause there now and hand back over to Tom.
Thank you both. We've got one question which I think probably Jonathan might have a look at, and I'll raise it at this stage. I'll read it out. I'm also going to click the answer live button. So if anyone's following the Q&A chat, you'll see it now appear. The question is, what about unilateral amendment powers? Presumably the distinction being drawn, the distinction between pensions cases and contracts, works better there. I wonder whether unilateral amendment powers is something that fed into this distinction.
I think it is, and actually I think it's an overextension of the principle from unilateral powers that has sort of caused this issue. In MNOPF, which was a unilateral power rectification case, it wasn't expressly discussed, but outward expression of accord wasn't looked for, and the judge, John Martin QC, said that his focus for the purposes of rectification was looking at what the trustee board was thinking. And that was based on Lord Justice Lewison's approach in Day and Day, which when you're dealing with a unilateral settlement, you know, voluntary dispositions, that sort of private trust world, if you've got a unilateral power, you don't need an outward expression of intention. So I suspect what's happened is historically, it's the historical derivation of pension schemes out of trusts and that notion of unilateral power that has perhaps led to it being seen as different. So whichever anonymous attendee sent that in has either had a good peek at my notes beforehand or asked the right question.
Or is psychic. No, quite right. Good. Thank you, questioner. Shall I pass on then to James?
Thanks, Tom. And now we're going to turn to evidential points. And we're going to deal with 3 evidential points. I'm going to deal with the first 2. And then Jonathan is going to deal with the third. The first one is what is meant by cogent evidence in the context of pensions rectification. The second is, given what we're told about subjective intention in Four Seasons, is the extent to which it's really necessary or useful to have every single participant trot along to give evidence. And the third, which Jonathan will deal with, is the link question of whose intention matters when you're dealing with corporate decision makers. So if I can start with the question of cogent evidence. It's often said that rectification requires cogent evidence. In Four Seasons itself, the Court of Appeal referred with endorsement to a passage in IBM in which Warren Jay, among other things, referred to exactly this requirement. My thesis, however, is going to be that that requirement is overstated. The requirement is an evidential one, it should be said. It's not a strictly legal one. The standard of proof in a rectification claim is the same as in any civil claim. It's the balance of probabilities, and AMP and Barker is one example of authority for that proposition. The point underlying the requirement, though, is that the written instrument, it is said, is likely to be the best guide to what the parties actually intended. And I've put there on the slide the quotation from Brightman, Lord Justice Brightman, in a case called Thomas Bates and Son and Wyndham's from the early 1980s, in which he makes exactly that point, that it's the fact that the parties signed it which suggests that it is the best indication of their intention. Now, in the case of a simple one-off contract, the logic of that position is clear. The parties in general terms can be expected to know what it is they're signing, or at the very least their lawyers can, and it's a fair inference that they wouldn't go to the formal act of signing something if they weren't happy with it. And in commercial dealings as well, there's also an obvious attraction in warding off speculative claims seeking to escape from clear contractual obligations, because as a matter of high policy, English law thinks that if parties sign up to a document, then on the basis of things, they should be held to it. And there's discussion of that, for example, in a case called the Olympic Pride, which is a 1980s decision of Mr. Justice Mustard, as he then was. And one can see that there may well be analogous situations with some pensions deeds, because you could suppose, for example, a simple and discrete amendment which was made by a deed. So, for example, you might reduce future accrual rates from 1/60th to 1/80th, for example, and the deed would do nothing else. And in that case, the deed would be clear and easy to understand. And anyone coming along later and saying, oh, no, we meant to reduce accrual to 1/90th, would properly face an uphill struggle in the face of the clear evidence of the deed. But the vast majority of pension claims are in a wholly different world. The error typically involves some unintended benefit change, resulting from some accident of drafting in Appendix 9 to Schedule 4 on page 83 or what have you. To expect any of the trustees or decision makers to have picked up on a point of such detail, if they even read the deed in full, is, I would suggest, in many cases, pretty fanciful. It will often have gone many, many years without being picked up even by the specialist pensions lawyers who have reviewed the deed from time to time in subsequent years. And when the mistake is an unintended benefit change, well, you could hardly expect trustees or corporate decision makers to carry around the detail of the previous rules themselves, or to undertake a tortuous comparison between the previous rules and the new ones. The notion, therefore, that in pensions cases you can take some comfort from the fact that the parties have signed the deed, that it truly represents their subjective intentions, seems to me to be particularly inapt. If anything, the complex formal deed may well be the worst evidence of their intentions. The better evidence is the documents that they can be expected to have read and digested and understood. Documents such as board papers or notes of advice from lawyers and so forth, and minutes of contemporaneous meetings, which on the face of things can be expected to accurately record what was said. So what then of arguments from certainty, the other justification for the cogency requirement? Well, here too it seems to me that the pensions context is quite different from the commercial contractual context. In the commercial context, as I said, it's desirable as a matter of high policy that the parties know where they stand, and the benefits of that can justify harsh results in particular cases. But compare that to pension schemes. Ordinarily, when one is talking about rectification, the scheme will have been administered as if the mistake had never occurred. People will have been paid benefits on the basis of the rules as they were believed to be, not as they were. Indeed, the fact that that is so is often evidence relied on. So granting rectification in those circumstances actually serves to promote certainty. Rather than have to unpick and recalculate benefits, remake your egg from the omelette, you can carry on as you were. It's difficult, therefore, it seems to me, to see any principled or policy justification for the cogent evidence requirement in most pensions rectification cases. Whether it's actually been decisive in any case, at least since the decision in Lansing-Linde almost 25 years ago, is another matter. But it seems to me it would in any event be better for it to be consigned to the jurisprudential dustbin. What matters is the evidence, is whether or not you can prove a mistake. And the evidence to do so will be necessary. The evidence necessary to do so will differ according to the facts, and in particular, the nature of the document you are seeking to rectify and the nature of the error it contains. That then moves us on to the next question. One quite often sees in rectification case claims statements from an awful lot of people involved. And there is a logic to that. Because we're dealing with subjective intention, there are few sources of direct evidence of what an individual subjectively intended other than their own evidence. If you're lucky, they may have said something in a meeting which was recorded in the minutes, but that's a pretty unlikely occurrence, certainly with the vast majority of the decision makers. Other documents, such as briefing papers and advice that I've referred to already, are not direct evidence of subjective intention, but evidence from which inferences as to that intention can be made. But that logic, I would suggest, is ultimately not very convincing. In most cases, the documents are going to be the key, and indeed perhaps the only really useful witness. And there are three reasons for that. First, there is the well-known point that courts are becoming increasingly sceptical of the value of witness testimony, given the fallibilities of human memory and our tendency to reconstruct past events, and in particular to reconstruct past events in our own favour. As it happens, it was Mr. Justice Leggett, as he then was, who put this issue into the spotlight in his well-known decision in Guessman and Credit Suisse. And although that hasn't met with universal acclaim amongst all lawyers, in general terms, it is now accepted as the proper approach to witness evidence. These issues are particularly stark in pensions rectification cases. In the first place, of course, they often involve matters that are historic, so memories will have faded. But this isn't just a matter of the passage of time. The process of drawing up a new deed will have been highly technical, and trustees and company decision makers will have had only intermittent involvement in it. They will, as they're probably obliged to do, have left the detail to their advisors. In those circumstances, to expect individuals to have meaningful recollections which go beyond the story told by the documents is, I would suggest, likely to be optimistic at best. Secondly, and relatedly, it will be a rare case in which the court's assessment of what objectively the parties were thinking differs from its conclusions as to what subjectively they were thinking. A court finding the facts is likely to be predisposed to a finding that people believed what the objective observer would conclude they believed. Where there are a large number of undocumented discussions which witnesses are able to recall, witness evidence may inform the court's conclusion as to what the parties were objectively intending, as well as what they were subjectively intending. But in general terms, one wouldn't expect that to occur very often in pensions cases. Key discussions would ordinarily be recorded in a document or in the minute of some meeting. And in fact, if I could just pause here, there is a bit of an irony underlying the subjective objective debate, which reached its head in 4 seasons. A great deal of ink and intellectual sweat has been spent on the debate. Some of the finest legal minds in the country had devoted huge amounts of time to earnest thought on it. In 4 seasons itself, the court noted that the number of judges or retired judges commenting on this in articles or lectures was, as they put it, unprecedented. But in 4 seasons itself, no one was able to cite a case after Chartbrook in which the judge made different findings as to the subjective intention of the parties on the one hand and their objective intention on the other. So in none of those cases did it make a difference what legal test was applied. Chartbrook, in that sense, really is a true outlier. The third reason is that there's a particular point about pensions cases, that the key issue is very often not what people intended so much as it is what they did not intend. That's because most rectifications cases are about unintended benefit changes, which have by mistake slipped into deeds intended to do something very different indeed. What really matters in those cases is not what the witnesses were thinking, but the very fact that no one mentioned the change later mistakenly made. If you have a proper documentary trail showing what the individuals were told the deed was intended to do, and it makes no mention of this other change, what better evidence could you get? Now, none of this is intended to suggest that witness evidence isn't necessary in some respects, because obviously sometimes the documents will give rise to questions which a witness can shut down. A statement from the draftsperson of the document in question explaining how the error came about can be extremely useful. Similarly, witnesses may be able to give evidence of their working practices or habits, not just their working practices or habits, but of the working practices of the trustee group or the company. And that may be useful. That will put the documents in context, show you what their significance is. But we're doubtful that the exercise of collating evidence from as many of those involved as possible is really fruitful. We can well see why people err on the side of caution in many cases to avoid the risk of the court disagreeing. But we think that the court would ultimately be wrong if it did require exhaustive witness evidence.
Thanks, James. I'm going to conclude this area of the talk now with a focus on, given this subjective test, whose evidence is it that we're trying to get, and how do we go about doing it? And the reason the subjective test that's being introduced may make this a little bit more complex is because almost inevitably in pensions cases, we're dealing with the decision maker, i.e. the person whose knowledge is to be attributed to the relevant corporate entity, and that decision maker involves multiple people. So it's a group or a board or a committee or a group of people to whom the relevant power has been delegated. So that raises two questions. The first is whose intention is relevant, and the second is how do you determine what their subjective intention was, if that's what counts. So just going back to first principles on corporate decision makers, slightly ironically relying on a judgment of Lord Hoffman in this talk, but there we are. In Meridian Global, he set out 3 types of rules of attribution of knowledge or intention from natural persons to corporate bodies. And these are rules that are a necessary part of corporate personality. He set out primary rules of attribution. These are those either stated in the corporate documentation or in the ordinary rules of company law, such as unanimous shareholder decision, that give particular individuals or groups power to act on behalf of the company. General rules of attribution by which all persons, whether legal or natural, can be bound by the acts of others, law of agency being the most obvious of those, because a properly appointed agent will bind the company as a matter of agency law, not any special corporate rule. And finally, in Meridian Global, he set out some exceptional cases where the court needs to find an answer, which inevitably he said was a matter of interpretation of the relevant rule. Just pausing there, quite often people quote Meridian Global as authority for how attribution works. That's true as far as it goes, but it's really a superstructural decision in that it sets out what you need to identify. It doesn't tell you how to go about doing it in any given case. So let's have a look at how that works in pension schemes particularly, and I'm taking IBM as the easiest example. Mr. Justice Warren's search was for the decision makers to be the relevant person. It's worth pausing there that you see from other cases, such as Hawksford trustees, that the decision maker may be different to the person who has authority to negotiate. So it's a factual exercise that you need to determine. First of all, who was it who factually made the decision? In IBM, that was the management committee. You then go on to ask yourself the legal question, which is how did they have the authority to make that decision. In IBM, it was held that the management committee acted within their delegated authority from the board. It appears, therefore, putting that through the Meridian Global superstructure, that was a primary company law rule that the management company had delegated authority as a matter of corporate law. Query if it was general agency. That authority was found, notwithstanding the absence of any documentary evidence conferring authority on the board, although there was no suggestion that there was any lack of awareness or concern on the part of the board. So that's quite an interesting example where authority was found in what seems to me, on the facts of the case, to be a relatively nebulous way. And that rather draws, it seems to me, quite a good lesson for pensions litigators particularly, that it's not just enough to look at the mistake and the factual question of who made the decision. You also need to go through the legal analytical exercise and the factual evidential exercise of working out what that authority was and where it came from. I suppose it's that factual and legal element that I want to draw your attention to. To conclude, this then raises the second question, which is, if after 4 seasons we're applying a subjective test, in respect of a board or a group, what does that actually mean? And I have to say, I think this is one of those areas where all bets are off. I'm going to offer you 2 possible options, and I can see there being scope for discussion about which is right. And the first question is this: can a board have a subjective intention at all? It seems to me, if you're trying to work that out, in principle, it could either be the views of the board members themselves shared and discussed internally, which you can prove from minutes or possibly witness evidence of what was discussed, but that wasn't revealed to the outside world. In that sense, it's subjective because it's private to the board, but it's known within the board as a whole. But what about, secondly, what about the coincident but unexpressed views of the individual board members? Is that, in fact, because it's tucked away in the bosom of each individual member, taken to be the subjective intention of the board as a whole? If that's right, how do you prove it? If the other one is right, how is that different to the objective intention of the board? If we just think about that option 2 again, just to give one further example, if the court is inquiring into the individual unexpressed intentions of the board members, you could get to 2 quite different conclusions. If something was unexpressed because it went without saying, then arguably there was agreement to it, there should be no rectification. If it was unexpressed because it wasn't thought about and wasn't intended, then there would be. The non-witness evidence materials from the board, and frankly, if you apply guesswork and witness evidence, is of limited weight in this point. Even the witness evidence wouldn't be much help. The materials on which you make that decision would be the same. It just wouldn't be discussed. So determining that, it seems to me, on option 2 on the slide there, is quite difficult. However, if in the pension scheme consent test doesn't require an outward expression of court crossing the line, it may be that when you're dealing with boards or other groups, 4 seasons doesn't actually make a difference. You still need to show what the board decided or intended on either view, and it might be difficult to get inside the hearts and minds of the individual members. And if you don't need to show that passing more widely, then you can just rely on the minutes and interpret them and decide what they meant. And that starts to look very much like what we already do as pensions litigators. So it seems to me it may be this evidential answer is the reason why 4 seasons, whilst it's doctrinally interesting, hasn't created great waves in its application in either the pensions context particularly or more broadly. If you need to look at intentions of groups, which are likely to be the relevant intentions most of the time, the tests are in substance the same. So it seems to us, or to me at least, that you need to look at how the board worked and what it was thinking, not necessarily or not only to prove subjective intention, but also to prove the appropriate rule of attribution and the substantive decision of the relevant decision maker. And so with that, I will hand over back to Tom for any other questions or wider discussion.
Thank you both. Can I start a bit of wider discussion, just while Q&As perhaps come in? And that's a question that I'm quite often asked in this context, which is about the evidence of the legal advisors and indeed the draftsman of the relevant document. And I wondered how helpful you thought getting the evidence of the draftsman was sort of part one, I suppose. And part two is, are we now to proof them on what they considered the subjective intentions of the relevant members were, whether it be the trustee board or the employers board? Or are we still asking them the same question about what instructions were you given and what did you do? So I wondered, yeah, from that perspective, evidence of the draftsman and evidence of the legal advisors?
And for my part, I think it's often potentially the most useful piece of evidence you can get, because they're the person who can explain how the mistake came about. And I'm in practice skeptical that there will be a difference between asking them what their instructions were and what they thought the subjective intentions of those instructing them were, because on the face of things, you'd expect the instructions to reflect the objective intentions. So I, for my part, wouldn't see, the subjective intentions. So I, for my part, wouldn't see a reason to depart from the ordinary practice that people have adopted in that regard.
Yeah, I'd agree with that. I suppose I'd just widen it in two areas, but I think that builds on what James said. First is, I think they'd be quite well placed to talk about the practices of those involved and actually how the drafting process worked, you know, in terms of, for instance, the level of detail or consideration that the decision maker appeared to them to be giving. Yeah. You can see that might be quite helpful contextual evidence that wouldn't be apparent from the documents necessarily or completely. And secondly, I suppose it opens up a little bit the opportunity to give evidence about subjective intention, but it's very hard to see how they could say anything other than, as James said, I thought they wanted to do what they told me they wanted to do.
Well, that second part is that I have in mind a case where there was a bit of dissent amongst the board. So if you actually pried a little further into people's intentions, you might have not got the same answer depending on who you spoke to. Which actually leads me on to the next question that we've got from Paul Newman. I'm going to again press answer live, which is looking at a situation where you have only got one trustee to whom oversight of the drafting of the pension scheme amendments is delegated, and the rest of the trustee board is content to leave it to that trustee, together with the advisors, to get the amendment right. If that's the way in which things are set up, then is that sufficient to establish the requisite subjective intention on the part of the board as a whole?
I would in principle say it is, because if you look at this as a question of delegation of authority and intention, the board is the decision maker. It intends X. It then delegates to trustee Y authority to give effect to change X. If trustee Y then does something or executes something that doesn't give effect to that change, then the board, as the decision maker, there's been an error in recording what the board intended. I've probably not expressed that as elegantly as Paul would have done, but I think that's the point.
Well, he knows where to find you if he wants a better answer. And then, and indeed, he said, for what it's worth, Jonathan, I agree. In the absence of any other questions, I am going to thank the 151 of you, because I can see from my participant bar how many people have been with us. So thank you very much indeed, everyone, for coming. Thank you, Jonathan and James, particularly for your talks. I have in mind an APL seminar in Budapest that Dan Schaffer asked a question at the end and started by thanking the speaker for a luxuriating afternoon, luxuriating in the law, and I feel rather similar. Thank you both very much indeed for those detailed presentations. Can I remind everyone we have 2 more of this year's New G lectures to go. The first, which is on the 24th of June, at 11 o'clock is Prudence in Investment with M. Scott Donald and David Pollard. The second is at 11 o'clock on the 30th of June, and it's Talking About Tax with Robert Ham, Michael Furness, and Jonathan Davey. Invites for the first of those, I'm told, went out yesterday. Invites for the others, for the last of those, the fourth talk, coming out next week. But any questions, do get in touch with us through details on the website. But just leaves me to thank today's speakers very much and to thank all of you for joining and hopefully see you at lecture number 3. Thanks very much.
Thanks, Tom.
Thank you.